And harm for real property, there's a couple case notes before our next case. 1, reasonable repairs. When damage to real property cannot be repaired so that the real property is restored to its original condition, measuring damages is relatively simple. The plaintiff is entitled to recover the diminution of value of the land measured as the difference between the market price of the property immediately before the damage and its market value immediately after. As Louisiana Gas illustrates, the difficulty arises when the damage to the property is repairable but only at a substantial cost. Generally, a plaintiff is entitled to recover the cost of restoration or repair only if that cost is reasonable. How does one determine when repairs are unreasonable? Jurisdictions differ. Some jurisdictions allow a plaintiff to recover the cost of repairs only when the cost does not exceed the diminution of the value to the property. Other jurisdictions permit the plaintiff recover the cost of restoration even where it exceeds the diminution in value as long as the cost of restoration does not exceed the pre-tort value of the property. Why place any ceiling on recovery of restoration costs? Why limit a plaintiff's recovery to the diminution in value? Why permit recovery of restoration costs beyond diminution in value? Consider the court's observations in the following cases. In General Outdoor Advertising Company versus LaSalle Realty Corporation, Indiana Appellate, 1966, a building owner brought an action to recover damages for injuries to the building caused by the large advertising sign a defendant erected on the roof of the building. An Indiana appellate court refused to limit the owner's damages to the diminution in value to the building. In reaching its holding, the court reasoned, in advocating the use of this rule of damages, the appellant states that if a plaintiff is allowed repair costs without the limitation of the before and after test, and he might be placed in a better position than he was before the damage. If a plaintiff is to be allowed repair costs when they exceed the market value of the property before the injury less the market value after the injury, plaintiff could choose not to repair the building and sell it, profiting to the extent of such excess of repair costs. Although this view seems equitable from a defendant's position, it is rather discriminate against the plaintiff. What if a plaintiff does not desire to sell his property? In this posture, the effect of the rule would be that where the restoration costs exceed the before and after measure, a plaintiff would receive the latter. Consequently, if he did not desire to sell the building, he would not receive damages sufficient to restore the building to its original condition. The before and after test, if used in cases of non-permanent injury, is in reality forcing the plaintiff to sell the building in order to restore himself to the same position enjoyed before the injury. Certainly, such a measure of damages partially compensates a plaintiff for injury done to his building and affords some protection to a part of his property rights. However, it would seem more proper to place the plaintiff in a position where he could be unrestricted in the exercise of his property rights of continued ownership or alienation. When these considerations are weighed against the possible windfall that might be given to the plaintiff, the former seems to take precedence over the latter. It is a defendant who places the plaintiff in such a position. Consequently, this court is of the opinion that under the above stated issues, the rights and equities of the plaintiff should be determinative without legal limits. In the facts at bar, it would seem reasonable to define permanent injury as being one wherein the cost of restoration exceeds the market value of the building prior to the injury. By adhering to such a definition, we, as a matter of law, raise a safeguard against a windfall while additionally protecting the property rights involved, such a rule is protective of the interests of both parties in their proper perspectives. In contrast, in Duquesne Light Company versus Woodland Hills School District of Pennsylvania Commonwealth, 1997. Appeal denied, 1998. A Pennsylvania appellate court reversed a trial court decision to exclude evidence of diminution in value and permit the plaintiffs to recover restoration costs. In reaching its holding, the court noted, under Pennsylvania law, the purpose of damages for injury or destruction of property by tortious conduct of another is to compensate the injured owner for the actual cost suffered by making him whole. Thus, the purpose is not to award a windfall. To the extent that a property owner is allowed to recover the cost of restoration that is greater than the diminution in market value, there is a possibility that the owner will receive a monetary windfall. By choosing to sell the property rather than restore it, the owner will profit to the extent that restoration costs recovered exceed the diminution in market value. The cost is exaggerated where the restoration costs would be permitted to approach the value of the property. In keeping with the purpose of compensatory damages and in prevention of windfall rewards, we find it necessary to interpret permanency in terms of whether or not the cost of repair would be unfair or inappropriate under the circumstances. Where the cost of repair is shown to be reasonable, the injury to real property is not permanent, and the cost of repair would be the appropriate measure of damages. However, where the cost of replacing the real property in its original condition disproportionately exceeds the diminution in the value of the property, the injury to real property is permanent, and the cost of repair would not be fair or appropriate. Rather, the proper measure of damages for permanent injury would be the difference between the value of the property before and after the harm. The restatement second of torts recognizes that either limitation can have inequitable results where a plaintiff holds injured property for personal use. Under such circumstances, no replacement property will adequately compensate the plaintiff, and the plaintiff has an incentive to make repairs that exceed the pre-tort market value of the property because the actual value of the property of the plaintiff exceeds the market value. Thus, the restatement and courts adopting the restatement, like the Louisiana Gas Court, allow a property owner who holds property for personal reasons to recover reasonable restoration costs, even if those costs exceed the value of the property, of the pre-tort value of the property. Four more minutes. Practical good sense. Under the restatement's reason personal rule, an owner may elect to recover restoration costs rather than diminution in value to the land only if in appropriate cases and only to the extent the restoration costs are reasonable. In general, this means the plaintiff's reason personal must be objectively reasonable. Additionally, the restoration costs must be objectively reasonable in light of the plaintiff's reason personal and the diminution in value to the land. See Osborne v. Hearst of Alaska, 1997. The reason personal rule, however, can be difficult for courts to apply because no clear guideline exists for distinguishing objectively reasonable restoration costs from unreasonable restoration costs. Instead, courts must be guided by what Professor Dobbs termed as practical good sense in determining when to award restoration costs under the reason personal rule. Accordingly, courts have reached varying results in applying the reason personal rule. Thus, in Wearsome v. Harder, Alaska again, the Alaska Supreme Court found that the cost to restore mature trees wrongfully removed from the plaintiff's unimproved land unreasonable despite the owner's reasons personal for wanting to restore the property. The court noted that the restoration costs were more than 3 times the pre-tort value of the property. The trees could be replaced with saplings that would restore the land to its pre-tort aesthetic over time, and that the landowner testified that he did not plan to build on the land until his son was finished with college. In contrast, Montana Supreme Court in McEwen v. MCR upheld an award of restoration costs to the plaintiff after the defendant negligently contaminated the soil underneath several ponds of the plaintiff's property, even though the $310,000 in restoration costs exceeded the $2,400 pre-tort value of the contaminated land. The court noted that the plaintiffs wished to restore the land so that they could continue to operate their family ranch on the land, and that the restoration costs awarded comported with the cheapest restoration alternative. Commercial uses. Should the plaintiff's use of injured property for commercial purposes preclude the plaintiff from recovering restoration costs under the reasoned personal rule? What if the plaintiff uses the property for both commercial and residential purposes? For example, should an owner of a duplex who lives in half and rents the other half be entitled to recover the costs to restore the duplex even if it exceeds the diminution in value to the property? Would it be a good solution to award costs of repair only if the plaintiff was already undertaking repair? Consider the effect of such a rule to require plaintiffs to borrow money for the repair expense in the face of the uncertainty of any recovery in litigation. Does this result matter? Consider further that what rule should attach if the plaintiff tries and fails to borrow money for the cost of repair. Alternatively, what if the plaintiff has taken steps before trial incompatible with repair, such as demolishing the injured structure? Permanent and temporary. Part 4. Can an injury to real property be both temporary and permanent? Should a plaintiff ever be able to recover both the diminution in value to the land and the cost of restoration? A majority of courts that have faced this issue have allowed recovery of both restoration costs and diminution in value when the defendant's nuisance or trespass has caused some temporary physical injury to the property. But despite the temporary injuries, remediation, the property's market value remains depressed. The cases representing this value have typically involved the contamination of the plaintiff's property as a result of the defendant's spilling or mishandling of hazardous substances. Plaintiffs have been entitled to recover the cost to remove the hazardous substances from their property and to restore their property to the pre-contamination condition. Further, they are often permitted stigma damages when the market value of the plaintiff's property remains depressed because of lingering fire concerns of the effect of environmental contamination on the property even after it has been cleaned. Such stigma damages compensate for loss of the property's market value resulting from the long-term negative perception of the property. These stigma damages are in excess of any recovery the plaintiff receives for the temporary injury itself. Statute of limitations. Part 5. As the Miller case illustrates, the nature of the trespass determines when the statute of limitation begins to run, as well as the damages the plaintiff may recover at trial. The nuisance or trespass is classified for these purposes as either permanent or temporary, often called continuous. If the trespass or nuisance that caused injury to the plaintiff's property is permanent, the plaintiff must seek to recover all damages, whether for past, present, or prospective injuries in a single action. If the trespass is continuous or temporary, the plaintiff may seek to recover damages for only those injuries that have already occurred, and the plaintiff is limited to recovery for injuries that occurred during the applicable limitations period. However, the plaintiff may file successive actions to recover damages for each new injury. To determine whether trespass or nuisance is permanent or temporary, courts consider different factors, including the abatability of the nuisance or the trespass, the continuous or sporadic nature of the injury caused by the nuisance or the trespass, and the ability to determine or estimate damages. So, time to read that case.